For years, there's been a quiet assumption floating around that once you reach a certain age, your rights somehow soften, fade, or quietly expire. Not because a court ruled it, not because Congress passed a law, but because people start telling seniors, sometimes gently, sometimes forcefully, that it's time to be realistic, that it's for your own good, that keeping your constitutional rights is somehow irresponsible, once the calendar flips past a certain number. And that idea has been repeated so often that many older Americans have started to believe it. But belief doesn't make it law. Age alone has never canceled a constitutional right, and it doesn't cancel it today. There is no federal statute that says turning 65, 70, or 80 strips a law-abiding citizen of the right to self-defense. There is no automatic trigger where birthdays replace due process. Yet seniors are disproportionately pressured into surrendering rights they still legally possess. Sometimes it comes from family members who mean well but don't understand the law. Sometimes it comes from doctors who speak outside their authority. Sometimes it comes from government forms written in intimidating language that makes compliance feel mandatory even when it's not. And sometimes it comes from silence, because no one ever explains that you still have a choice. What's rarely discussed is how constitutional rights don't fade with age, they require a legal process to be limited, just like they do for anyone else. That process matters. It requires evidence. It requires notice. It requires an opportunity to be heard. Rights cannot be removed because someone is uncomfortable with them, nervous about them, or assumes risk where none has been legally proven. But when seniors voluntarily give up those rights without a legal requirement, the system doesn't push back. It accepts the surrender quietly, and once that door closes, reopening it is far harder than people realize. Many seniors don't realize that voluntarily giving something up can permanently change their legal footing. When you surrender a right without a court order, there's no hearing, no ruling, no official finding to challenge later. The record simply shows compliance. And that compliance is often misinterpreted later as proof that the right was never contested in the first place. That's not a theory, that's how bureaucratic systems work. Silence becomes consent, cooperation becomes confirmation, and misinformation becomes precedent. There's also a cultural pressure at play. Society often frames self-defense as something for the young, the strong, the fast. But the reality is exactly the opposite. Those who are physically weaker, slower, or more vulnerable are often the ones who need legal self-defense protections the most. Seniors face higher risks of targeted crime, longer emergency response times, and greater physical consequences from even minor confrontations. Yet they're the very group being told to step aside, to rely solely on others, to trade independence for perceived safety. That trade is rarely voluntary. It's coerced by fear and misunderstanding. And let's talk about fear, because it's the most powerful force in this conversation. Fear of making a mistake, fear of violating a law that sounds complex, fear of being judged, fear of being labeled incapable. That fear leads many seniors to overcomply, to surrender first and ask questions later, if they ask at all. But the law does not require fear-based decisions. It requires informed ones. Knowing your rights doesn't make you reckless, it makes you protected. Another misconception is that exercising constitutional rights requires confrontation or defiance. It doesn't. Understanding your rights is not about resisting authority, it's about ensuring authority follows the law. Seniors who know where their rights begin and end are often the most compliant citizens because they operate within clear boundaries, not imagined ones. The problem is when those boundaries are drawn by rumor instead of statute, by assumption instead of fact. There's also a quiet dignity in not surrendering a right just because someone suggests you should. Independence doesn't vanish with age. Judgment doesn't disappear. Legal competence is not measured by wrinkles or retirement status. It's measured by due process, and due process does not operate on assumptions. Yet every day, seniors are nudged toward silence, told not to ask questions, told it's simpler to give something up than to understand it. Simpler, yes, but safer in the long run, not always. The truth is, rights that are exercised responsibly tend to be respected. Rights that are abandoned quietly tend to be forgotten. And once forgotten, they're rarely defended by others. If you don't value your own rights enough to understand them, the system has no incentive to value them for you. That's not cynicism, that's reality. This isn't about clinging to the past or refusing change. It's about recognizing that constitutional protections were designed to outlast generations, not expire with them. They were written with the understanding that vulnerability exists at every stage of life, and that the law, not fear, not pressure, not convenience, is what governs when a right can be limited. So before any senior gives up a right because someone implied they should, or because a form sounded final, or because silence felt safer than questions. Remember this: age does not erase the Constitution, but surrender can. There's a quiet but powerful myth that starts circulating the moment someone reaches a certain age, and it sounds reasonable enough that many people never challenge it. The idea is that getting older automatically means giving things up, driving less, traveling less, deciding less for yourself, and eventually surrendering rights you've exercised responsibly your entire life. It's rarely stated outright, but it's implied in conversations, paperwork, and well-meaning advice. And over time, that implication starts to feel like law, even though it isn't. The truth is, age by itself has never canceled a constitutional right. Not voting, not speaking freely, not defending yourself. There is no page in federal law where a birthday flips a switch and turns a law-abiding citizen into someone who must ask permission to remain independent. Yet many seniors quietly accept that narrative because it's easier than pushing back, easier than asking questions, easier than being told they're making things complicated. But what's actually happening is far more serious. Rights are being surrendered without due process, and once that happens, there's no alarm bell that goes off to warn you. Due process is not a technicality. It's the backbone of every constitutional protection. It exists specifically to prevent rights from being taken based on assumption, fear, or convenience. It requires notice, evidence, and an opportunity to be heard. None of that disappears with age, and yet seniors are often encouraged to bypass that process entirely, to hand over rights voluntarily because it might be safer or it avoids problems. What rarely gets explained is that voluntary surrender is not the same as a legal determination. One can be challenged, the other cannot. Many older Americans don't realize that once a right is surrendered without a formal legal finding, it can be incredibly difficult to reclaim. There's no ruling to appeal, no record of objection, no moment where the law was forced to justify itself. The system simply notes compliance and moves on. That silence becomes the official story. Later, when someone asks why a right was given up, the answer becomes because they agreed to it, even if that agreement was based on incomplete or incorrect information. This is where misinformation does the most damage. Seniors are often told, directly or indirectly, that keeping certain rights creates liability, that it invites scrutiny, or that it signals irresponsibility. Forms are writ in language that sounds mandatory even when it's optional. Conversations are framed as guidance when they're really suggestions shaped by fear. And because many seniors value cooperation and civility, they comply first and research later, if at all. But the law doesn't reward unexamined compliance, it rewards clarity. There's also an unspoken cultural bias at work. Society tends to equate independence with youth and vulnerability with age. But vulnerability is exactly why constitutional protections matter. Seniors are more likely to live alone, more likely to be targeted by crime, and more likely to face longer response times when something goes wrong. Self-defense, in its legal sense, is not about aggression. It's about autonomy and the ability to protect oneself when help is not immediately available. Suggesting that seniors should relinquish that autonomy without a legal reason is not protective. It's dismissive. Another damaging assumption is that exercising a right means being confrontational. That's simply not true. Understanding your rights doesn't require defiance or hostility. It requires knowledge. Seniors who understand the law are often the most careful, compliant, and responsible citizens because they know exactly where the boundaries are. The danger comes from uncertainty, from being told it's complicated, and discouraged from learning more. Confusion benefits systems, not individuals. Fear plays a central role here. Fear of making a mistake. Fear of being misunderstood, fear of being judged as incapable. That fear pushes people towards silence and surrender, even when the law doesn't require it. But constitutional rights were never designed to be exercised only by the fearless. They were designed to protect the vulnerable, including those who feel pressured to step aside quietly. It's also worth recognizing how easily independence can be eroded one small decision at a time. Rarely does anyone wake up and decide to give up their rights wholesale. It happens in pieces. One form, one suggestion, one uncomfortable conversation. Each step feels minor, even responsible. But taken together, they amount to a permanent shift in legal standing. And once that shift happens, others begin making decisions for you, often without asking. None of this is about refusing change or ignoring legitimate concerns. It's about understanding that the Constitution does not operate on vibes, assumptions, or age brackets. It operates on law. If a right is going to be limited, the law must justify it, not the other way around. Seniors deserve the same presumption of competence and autonomy they were afforded decades ago, unless and until a legal process says otherwise. Rights that are understood are harder to take. Rights that are quietly abandoned are easy to forget. And history shows that once a group stops defending its own rights, others are rarely eager to step in on their behalf. Knowing where you stand legally is not stubbornness, it's self-respect. So before accepting the idea that age requires surrender, remember this: the Constitution does not fade with time, but it can disappear through silence.